Hello, and welcome to our webinar on FRAND decisions following Huawei and ZTE. My name is James Marshall from the Taylor Wessing London office, and I'm delighted to be joined by my colleagues Dieter Kammler from Germany, Wim Maas from the Netherlands, and Chris Thornham, also from the UK. In today's webinar, we're going to discuss the approaches of national courts in Europe to the question of whether and in what circumstances an injunction should be granted for infringement of a standard essential patent, and in particular how the courts in Germany, Netherlands and the UK are interpreting the requirements laid down by the Court of Justice of the European Union in its July 2015 judgment in Huawei and ZTE. We will be analysing the latest on the steps advisable for an owner of a standard essential patent to take to avoid an injunction being refused on competition law grounds, namely an abuse of dominant position, and also the steps that a defendant ought to follow if it wishes to raise a defence of abuse. We have divided matters up into an agenda as follows. I will speak about some additional aspects of the recent UK decision in Unward Planet and Huawei, and then start the discussion as to the patentee's obligations following the Court of Justice's decision, explaining the UK court's views. And I will then be followed by Dieter and Wim, respectively, as to the German and Dutch positions. As is well known, since late 2015, there have been a series of decisions from Germany, both at first instance and on appeal, where the precise legal position has ebbed and flowed in a number of respects. In the Netherlands, we now have the decision of the District Court of The Hague in the Philips and Arcos case. Before we discuss the detail, I'd like first to mention a couple of housekeeping issues. First, we would greatly welcome questions. There's a Q&A box in the corner of your screen. If you wish to submit questions using that facility, we will get back to you as soon as we can. Also, if you're able to spare a minute at the end of the webinar to complete the survey, that valuable feedback would be much appreciated. As I mentioned, last month, of course, we received the eagerly awaited decision of the English Patents Court in the Unward Planet and Huawei case. In that decision, Mr. Justice Burst not only carefully considered the CJEU's decision in Huawei and ZTE, which Chris and I will be explaining a little later, he dealt with some other matters too. First, he set FRAND terms after considering respective terms put forward by both parties, Unward Planet and Huawei. Notably, he expressed the view that there was only a single set of terms that are FRAND in a given set of circumstances, rather than FRAND being a range. We shall see shortly whether or not the German and Dutch courts agree with this. Those FRAND terms set by the English court included not only royalty rate, but also geographical scope. In the particular circumstances of the case, and the position would likely be the same in many others, a UK portfolio-only license was found not to be FRAND. A FRAND license between the parties was instead a worldwide license. Chris will explain towards the end of today's webinar what this means now for Huawei, given that it was only prepared to enter into a UK portfolio license, not a worldwide one. Today, we will not have time to address the methodology of the setting of the royalty rate. We intend, though, to hold a future webinar in early June to discuss these interesting and important issues. Further details will be sent out in due course, but the date currently proposed is 7th of June. The second point that I'd like to mention about the English court's decision is that Mr. Justice Burse was at pains to point out that the FRAND undertaking is enforceable in court. In other words, in his view, as a matter of legal analysis, a defendant that is prepared to accept whatever terms are found by a court or arbitrator to be FRAND, then has a defence to a claim for an injunction on the basis of the enforceability of the FRAND undertaking without even having to rely on competition law. The court contrasted its view with the facts before the Court of Justice in Huawei and ZTE, which of course had approached the matter from the other starting point, i.e. competition law. We shall hear shortly from Dieter as to whether the German court's approach is the same or diverges on this point. The third point from the judgment, which actually does relate to competition law defences, concerns the question of dominance. The argument that there should be no injunction on competition law grounds is based on an alleged abuse of dominant position in the market for licensing a particular standard essential patents. As seen by the CJEU, seeking an injunction is tantamount to a refusal to grant licenses on FRAND terms. Interestingly, the English court suggested that it could have found that Unward Planet was not in a dominant position if a proper economic analysis had been done in the evidence, which it had not been. The judge contemplated there could be circumstances where, because of the FRAND undertaking and the potential for hold out by the implementer, a particular patentee may be able to rebut the presumption that it is in a dominant position. As I say, on the evidence presented, there was insufficient material on which the judge felt able to do anything other than infer dominance on the part of Unward Planet. In practical terms, in future cases, when competition law defences are raised, we can expect standard essential patentees to continue to dispute dominance and perhaps adduce more economic evidence to support that position than had been the case in the Unward Planet litigation. Given the uncertainty, though, as to whether such arguments would succeed, we can still expect patentees nevertheless to try and comply as closely as possible with the Huawei ZTE scheme as they reasonably can. So let's now look at the patentee's obligations as provided for by the Court of Justice in Huawei and ZTE, and how the national courts have been considering and interpreting those. First, a quick reminder of what the Court of Justice said. The key points from the decision regarding the obligations of the patentee are as follows. Prior to an action for an injunction, it is for the patentee to alert the alleged infringer of the infringement complained about by designating that standard essential patent and specifying the way it has been infringed. After the defendant has expressed a willingness to conclude a license on FRAND terms, it is then for the patentee to present a specific written offer on FRAND terms, specifying in particular the amount of royalty and the way in which that royalty is to be calculated. As I say, we will now look at the national court approaches to those requirements. First, the UK. The English court accepts that bringing proceedings without any notice of any kind will automatically be an abuse. But subject to that, it has thus far adopted quite a flexible approach to the Huawei ZTE scheme. Mr. Justice Burt's view was that the Huawei ZTE requirements were not a rigid set of rules, but rather set out a standard of behaviour against which both parties' conduct can be measured. We will see in a moment from Dieter and Wim whether that accords with the view of the German and Dutch courts. Although providing claim charts before starting proceedings is clearly the safe approach, the English court has certainly not held that that level of information is always required. It will depend on the circumstances. On the facts of the Unwired Planet case, there was prior contact to some degree before the proceedings were brought, albeit no claim charts were provided. The fact that Huawei is a sophisticated organization was a relevant factor. The judge stated there was no basis to assume that Huawei interpreted the claim for the injunction as a refusal to license. As to the second condition, again, the provision of written licensing terms prior to starting commencement of proceedings will usually be advisable. But this appears to be regarded by the English court not as an absolute requirement. On the facts of Unwired Planet, the patentee provided the key terms of a license offer, including its royalty, to the defendant a few weeks after commencing proceedings. Whilst this was outside the letter of the CJEU scheme, it was only by a short period of time, and in the view of the English court, not sufficient for a finding of abuse. In fact, the judge went as far as to say that this just reinforced the obvious, namely that the issuing of proceedings did not indicate that Unwired Planet did not wish to license its standard essential patents. Thus, the court expressly rejected Huawei's argument that there should be no injunction because they were sued before FRAND terms were offered. When it comes to the substance of the terms of the SEP owner's offer, the English court does not consider that it is necessary for the terms offered by the patentee actually to be FRAND. And the judge is using FRAND here in the sense that FRAND is a single set of terms that a court or arbitrator would decide to be FRAND. An offer with a royalty that is higher than the court-determined FRAND rate is legitimate, provided it does not disrupt or prejudice the negotiations, to use the judge's words. It is enough that reasonable concrete proposals are put forward. It is the patentee's commitment to FRAND licensing that counts. Again, Dieter will have something to say on both these points in just a moment. Finally, from me, the judge also made an interesting comment about the possibility of a patentee later correcting an abuse committed by starting the litigation prematurely. He felt that if, contrary to his view, there had been an abusive commencement by Unwired Planet in April 2014, this could have justified a refusal of an injunction 12 months later in April 2015, but not in 2017. Any prejudice that may have been suffered by Huawei would have been outweighed by time and Huawei's stance in relation to a FRAND license. I will now hand over to Dieter, who will explain the latest position in Germany regarding the patentee's conditions.
Thank you, James. As James already indicated, there have been several decisions on FRAND since Huawei and ZTE in Germany. On this first slide, I indicated three of the most recent decisions in this field which are widely discussed in Germany. Now, before going into the details regarding the patentee's conditions, I'd like to point out two general aspects in the court's approach to FRAND cases in Germany. The German courts have always relied on European competition law as basis for the FRAND defense, and were very reluctant to accept the FRAND defense on the basis of the FRAND undertaking as such. Even if the FRAND undertaking leads to a contractual liability against any implementer, it is widely assumed by German judges that it will not go beyond the obligations of the patentee under Article 102 TFEU. Therefore, the focus in Germany has always been on European competition law. Also, please keep in mind that in German infringement proceedings, the injunction is the automatic remedy if the court finds the patent infringed and the defendant cannot rely on a defense. Therefore, if the FRAND defense fails, the court will issue the injunction after the trial without a follow-up hearing on remedies and without any judicial discretion. Regarding the patentee's notice about the alleged infringement, the courts in Düsseldorf are very generous and require simply naming the SCP and the concerned standard. Düsseldorf does not require claim charts at this initial stage. The Mannheim court once required a brief explanation of the infringement and left it open whether claim charts might be required. They are certainly sufficient. In both courts, the notice has to be given for the asserted patent and not just for parallel patents in other jurisdictions. If the defendant in reply indicates its willingness to take a license, the patentee will have to make a license offer on FRAND terms and provide an explanation how the royalty rates are calculated. Other than in the UK, German courts require a fully elaborated license agreement. The offer has to include all legal terms usually included in such license agreements. Just indicating the key financial parameters without a legal framework will not be enough. Regarding the substance of the license offer, both Mannheim and Düsseldorf have emphasized that there's not just one set of FRAND conditions. Unlike the UK High Court decided, in Germany FRAND rather defines a range of conditions which are not abusive and not discriminatory under Article 102 TFEU. The German courts will therefore not go all the way and set a specific FRAND rate themselves. Rather, within the defined range, the patentee will have wide discretion to set the terms of the license offer. At last, the patentee has to explain the way in which the royalties are calculated. This requires not just an explanation of the royalty rate and the royalty base, but also an explanation why the patentee believes the royalty rate to be FRAND. The patentee has to explain the economic reasoning behind the royalty rate setting and that it is in line with comparable licenses concluded with third parties. Even if a local subsidiary is sued, it is sufficient if these obligations are fulfilled in relation to the defendant's parent company, because group licenses concluded by the parent company are usual in the business. According to the Mannheim Regional Court in the Philips against Arcos, against ACES, HTC and Wyco cases, the patentee's conditions have to be fulfilled before bringing the action for an injunction. Defendants should be able to negotiate without the pressure of pending injunction proceedings, and under this assumption, a FRAND offer and explanation after filing the action for an injunction is too late and will not be taken into account. In Mannheim, the patentee will have to withdraw a premature injunction action, fulfill the requirements of Huawei and ZTE, and then file the action again. While the Düsseldorf Higher Regional Court in Siswell and Higher generally agrees that the patentee's conditions have to be fulfilled before bringing the action, in Düsseldorf, omissions can be remedied at a later stage within the procedural deadlines, so the conditions can be properly discussed in the oral hearing. And now I hand over to Wim, who will explain the situation in the Netherlands.
Thank you very much, Dieter. Before the Huawei ZTE judgment of the European Court of Justice, the important Dutch FRAND cases were limited to 3 cases: the Philips SK Cassette case, LG Sony case and the Samsung Apple cases. The approach of the Dutch court in these cases has been very patentee friendly. In short, if you start trading without the necessary licenses in place, the patentee is allowed to seek an injunction. Therefore, the burden of getting the FRAND license was until the Huawei judgment only on the licensee. if a patentee was not willing to grant a license on FRAND terms, the willing licensee had only one option, and that was to go to court to claim a FRAND license from the patentee, which in the Dutch case law never has happened. This approach was totally different than the approach of the German courts at the time. Of course, this Dutch approach had to change after the Huawei judgment in July 2015, but it was not, as James already mentioned, until very recently that we had our first post-Huawei FRAND case in the Netherlands, the Argos Philips case of February 8, 2017. Many more Dutch FRAND judgments will be expected in the coming years, and there are a few of which we know for sure that they are already in the pipeline for this year, because our firm is involved in some of them. We have some takeaways from the Argos Philips judgment for you. First of all, please take into account that this case was filed by Argos in response to separate infringement proceedings filed by Philips relating to 3 SEPs for the UMTS standard. Argos asked the court to declare that the Philips license offer was not FRAND and that their own offer, by the way about a factor 10 apart from one another, was FRAND. It was therefore not a typical FRAND case in which the patentee claimed for an injunction and in which the defendant raised a FRAND defense to try and prevent the injunction. Therefore, the regime as set out by the Court of Justice in the Huawei ZTE ruling was therefore not applicable to the latter. The court did, however, rule on some very interesting points. Firstly, the court ruled that it was Argos who was not willing to negotiate. According to the judgment, Argos had stated that they did not want to spend more than a couple of €1,000 for the license, and otherwise Philips should just take them to court. And by the way, as already mentioned, in the German case of Philips against Argos, Argos was considered a willing licensee. So there's a difference between the Dutch and the German court in the same case, although it had some different way it started. Another takeaway is that the court sees the Huawei judgment as a new moment for negotiations. What happened in the negotiations between Philips and Argos was not taken into account, even when this behavior was not in line with the regime of the Court of Justice. This leads me to believe that the Dutch court is in line with the UK court, that parties are not obliged to follow the Huawei regime to the letter, but that the regime is considered to be somewhat of a gold standard to assess FRAND behavior of the patentee and the defendant. And thirdly, the court rules that there is no such thing as only one FRAND license. In the eyes of the Dutch court, FRAND, like also in the German courts, is a bandwidth, or in other words, a range. This is, at least in theory, a different view than of the UK court. However, we believe that in practice it probably does not make much of a difference, since the UK court is also mainly assessing FRAND behavior of the parties. The Dutch court also showed willingness to examine the FRANDness of specific terms of the license proposal of Philips. However, the court also explicitly mentions that, taking into account again that FRAND is a bandwidth, it was up to Argos to try and negotiate these specific terms of which they believe that they are not FRAND. And by not raising this during negotiations, it showed, again according to the Dutch court, that Argos was in fact not really willing to get a license. And finally, we see at least a hint in the Argos judgment that the court is likely to shift the burden of proof that the offer is FRAND to the patentee. The patentee has to prove that. At least we see a hint of that. This could lead to an order to the patentee to disclose comparable already existing licenses. As I said, it's a hint, so it's not decided yet. In earlier FRAND cases, the Dutch court was not willing to grant such orders, but maybe after Huawei this has changed. We expect to see this shortly in an upcoming case in which our firm is involved, so then we will know more about this topic. We will now turn to the topic of the obligations of the defendant, which arise from the Huawei ZTE judgment. And these obligations can be summarized as follows. The defendant should have expressed actual willingness to get a license. That's the first obligation. He also has to provide a detailed counteroffer to the patentee. That's the second obligation. And if this counteroffer is rejected, the third obligation is that the defendant should post some sort of security, such as a bank guarantee or a deposit, for the payment obligation arising from its own counteroffer. Let us now have a look again at the approaches of the different national courts. I will start with, of course, the Netherlands. And there's actually only a ruling on one of the obligations, and that is the willingness. The Dutch court applied, at least that is my opinion, a strict approach here. A defendant should be able to convince the court that he was really willing to negotiate. And from the Argos judgment, we learned that after the defendant has received the first license proposal from the patentee, he can certainly not sit back and try to play hardball during these negotiations. He should negotiate on specific terms he does not consider to be FRAND, and if he does not do that, he will, by the Dutch court, not considered to be a willing licensee. This seems at least to be a stricter approach than that of the German courts. And we will now look at the German courts. Dieter, the floor is yours again.
Thank you, Wim. In Germany, the defendant's conditions are always reactions to the patentee's conditions. If the patentee's conditions are not fulfilled, the defendant is under no obligation to fulfill its conditions. Once the defendant is put on notice, the defendant has to indicate its willingness to take a license upon FRAND terms. This is not a very high threshold, and a general statement is enough. Specific conditions for the license are not required. Quite the opposite is true. If the defendant specifies certain conditions which the court finds inappropriate, the defendant may even be treated as an unwilling licensee. Once the patentee made a proper FRAND offer, the defendant has to react without delay. If the patentee's offer is not accepted, the defendant generally has to make a counteroffer. Here the same standards apply. The counteroffer has to be actually FRAND and include all legal terms required for a usual license. If the defendant is a reseller, it can point to a counteroffer by a supplier. The patentee cannot refuse a reasonable counteroffer just because it's not made by the defendant itself. However, this does not limit the patentee's discretion to sue infringers on every level of the distribution chain, including resellers. Once the patentee has rejected the counteroffer, the defendant has to provide accounting for past use of the SEP. Since FRAND offers are usually for worldwide patent portfolio, accounting also has to be provided on a worldwide basis. In addition, the defendant has to provide a security. This can be done by a bank guarantee or by paying cash into the court's account. The amount of the security is still in dispute. It appears settled that the security has to cover the actual FRAND royalty rate for the entire portfolio. The safe option is a security in accordance with the patentee's license offer. The minimum requirement is compliance with the defendant's own counteroffer. Typically, the latter is combined with a safety margin. Whether the security has to cover the worldwide past use or only past use in Germany is still open. It is also not finally settled whether the security will have to cover damages for time periods even before the injunction proceedings were started. Such claims for past damages can be enforced at any time and independently of a FRAND defense. Therefore, one could argue that the security in this context should not be tied to the damage claims unrelated to the FRAND defense. The prevailing view, however, seems to be that past damages also have to be covered by the security. Please note that at least according to the Düsseldorf Regional Court, the timelines for providing accounting and security for the defendant are very tight. This has to be done usually within 2 weeks. Accounting and the security should therefore be prepared as soon as the counteroffer is submitted so that everything is ready once the patentee rejects the counteroffer. In the recent Siswell and Higher case, which was decided on March 30 this year, the Düsseldorf Higher Regional Court also provided important additional guidance for patentees and defendants in this FRAND game. The fully reasoned judgment is not yet available, but the court's guidance order prior to the hearing was published. If the license offer is to a patent portfolio, the patentee will have to substantiate that the entire portfolio is essential to the standard. When the bundling of different patents into a portfolio is questioned by the defendant, the patentee has to provide detailed claim charts, at least for a so-called proud list of representative patents, to the court. In the Siswell and Higher case, it was agreed that 10 to 15 claim charts would be sufficient given the size of the portfolio. The selection criteria for these patents in the proud list have to be explained to the court. With this burden of proof, patentees should be ready to present claim charts in any event, even if they are not required for the initial notice of infringement. Moreover, while German courts are rather generous to the patentees when it comes to setting FRAND terms, the Düsseldorf Higher Regional Court now requires the patentee to disclose prior licenses with third parties. In the view of the Düsseldorf Higher Regional Court, published royalty rates for other portfolios may be indicative of the adequate royalty. However, the patentee's own licenses to the same portfolio carry much more weight. These prior licenses of the patentee are also required to exclude discrimination. The Düsseldorf Higher Regional Court also made it clear that licenses of the patentee's legal predecessors are also relevant as far as they are still in force. The patentee will therefore be expected to make these prior licenses by previous patent owners available to the court. These new obligations of the patentee will certainly shift the balance in favor of defendants in future cases. I will now hand over to Chris, who will explain the UK High Court's approach to the defendant's conditions.
Thank you, Dieter. So the UK's approach, I think, first off, it's important to stress that when Mr. Justice Burse was considering the issues of FRAND, he considered that the Huawei and ZTE scheme is to be regarded as a standard of behaviour against which the parties' actions are to be measured, rather than a rigid set of rules. So we would expect in the UK an adoption of a flexible approach. In the Unwired Planet decision, there's actually relatively little guidance on the details of a defendant's obligations, but there are a few points that we can draw out, and so I'll address those. The first point about willingness and a diligent response by the defendant is a point there on the slides. 2 months to negotiate an NDA was considered to be acceptable on the part of the implementer. That wasn't undue delay or lack of willingness. Without prejudice, negotiations had been going on, and those aren't admissible in the court. The contents of them aren't admissible. But it was admissible the fact that these had been going on in the background. What the court did emphasize was that open correspondence can help show that diligence and willingness. And so for parties who are in negotiation, one might expect to see at least one round of open correspondence. When it comes to the provision of a FRAND counteroffer by an implementer, It's informative what happened in the Unwired Planet case. First off, remember that Huawei only made a UK counteroffer, a UK-only license. The fact that that counteroffer was a number of times lower than what would be a UK benchmark didn't prejudice the negotiations in the judgment of the court. It was therefore behaviour within the range that was considered to be acceptable, just as a patent owner might ask for a license fee that is higher than the actual ultimately determined benchmark. What was more significant, however, was the fact that Huawei refused a worldwide license. And as that was the ultimately determined FRAND license, i.e. a worldwide license, not just UK, a failure to counteroffer and engage on a worldwide license was non-FRAND behaviour. So that was decisive in the Unwired Planet case. Other points regarding bank guarantee. We've seen in Germany that there are detailed considerations, but in the UK case, in Unwired Planet, the issue just did not arise. So there are a number of other points that we can take from the Unwired Planet decision. When we turn to the consequences of the findings, importantly, the question of injunctions now comes to the fore. The court will grant an injunction against an implementer that is not prepared to take a license on FRAND terms, in this case a worldwide license. So the question now is, where do we go from here in the Unwired Planet case? The normal practice is that there is a post-judgment directions hearing, and that is to be scheduled. We know that Unwired Planet has provided its worldwide license terms, but an injunction has not yet actually been entered or ordered by the court. So the issue now arises whether an injunction will be imposed or not, and how that implementer, in this case Huawei, may avoid an injunction or whether it would be ordered. Clearly, if an implementer agrees in this context to an adjudicated worldwide license, then it can avoid an injunction. Alternatively, one can expect that there may be an appeal of the first instance decision, and it may be that an implementer, in this case Huawei, might seek a stay of any injunction order pending the determination of an appeal. So we will have to see. We'll have to see how that develops, and as it does, we will report, of course. What we haven't done today is go into the detailed calculations and methodology for a FRAND royalty calculation. We are going to provide a webinar on that specific topic, and as James mentioned at the start of the webinar, we'll be doing that in early June. And I think we'll follow up with details of that. I think we expect that will be on the 7th of June. So I think that that covers the different points that we have addressed over the course of this webinar. If people do have questions, after the webinar, then please do let us know, and certainly we would welcome feedback too. I think James mentioned there are some feedback forms. So thank you again for everybody attending, and we look forward to speaking again, and hopefully in the near future. Thank you.